I'm Mark Lathem, and I'm a lawyer who has been practicing law in Richmond Hill, Ontario, focusing on the areas of real estate, business, and estates law. And over the last 20 years, we've purchased literally thousands of new homes and condominiums on behalf of clients. And the purpose of this video really is to provide for our clients and our prospective clients the typical explanation that I give of new home contracts and the things that a typical new home purchaser must be aware of. Now, I want to make a comment. The process of purchasing a condominium is different from buying a home, and we will deal with that in a separate video. Now, the purchase of a new home in the province of Ontario, quite frankly, is a reasonably safe proposition because of the amount of government regulation involved. However, the only risk it really carries with it is that of the general market conditions and not the contract itself, nor dealing with the builder. Now, there are really three regulations that come into place when one is buying a new home. Those are the Planning Act, the Building Code Act, and the New Home Warranties Plan Act. And I want to go through all three of those and explain how they impact on you as a new home buyer and the contract that you're signing. First is the Planning Act, and the Planning Act allows the municipality to regulate the land use within its boundaries and also the construction of the infrastructure and buildings. And where it comes to impact on the new home buyer is how it relates to the construction of the infrastructure or the subdivision and the services of the water, sewer, and drainage that goes along with the agreement. And essentially what happens, number one, is the municipality requires the land developer to post a bond equivalent to the cost of constructing the subdivision works, so that if the builder or developer goes bankrupt, neither the municipality or the homeowner are burdened with the cost of completing the subdivision works. From a practical point of view, one of the things that's key to developing a subdivision is the draining and grading of the subdivision so that the basements and things like this do not fill with water when it rains. This results in the municipality requiring that new homeowners and lots have easements and be required to provide easements even after closing if flooding problems occur. In addition to this, there is the requirement typically that the grading be completed 1 year following the backfilling of the basement itself, which typically means that it's being completed following the closing. And it comes with a warranty period that goes up to 5 years, where the municipality can call the builder back to remedy any problems relating to things such as the drainage of the subdivision. And this is reflected in certain restrictions on the title of the property. The second thing is the Building Code Act. And the Building Code Act is the act which allows the municipality to set the minimum construction standards and inspect the property as it's being built. The area where it really impacts on a new home buyer, aside from making sure that they're getting a good quality home, is the fact that the municipality becomes the arbitrator of when the house is safe to move in, complete or not. And there's a specific section of the Building Code Act which sets out when an occupancy permit is required. So as between the purchaser and the builder, the municipality through this program, through this requirement, becomes the arbitrator of when the house must be closed. And the third thing is the Ontario New Home Warranty Plan Act itself. And in Ontario, registration by builders under the New Home Warranty Plan Act in individual houses is mandatory. If you're buying from a builder who's not registered, then you may or most likely will have a serious problem, and it is also illegal. But what the New Home Warranty Plan Act does is it essentially acts almost like a bonding agency for builders that guarantees to a new home buyer protection against a builder who is dishonest or may simply become insolvent. What the New Home Warranty Plan Act guarantees is it guarantees essentially the deposits given by the buyer to the builder up to $40,000 while the home is under construction. If the deposits exceed $40,000, then they're not insured through TARION, and there needs to be some other mechanism to ensure the deposits themselves. The second thing, it guarantees the builder's obligations as far as paying any penalties if the builder gives improper notice of any particular closing date. And the third thing it does, it guarantees the actual quality of the building itself, and that is that most of the items in the building are guaranteed for 1 year against general defects. The mechanical systems are guaranteed for up to 2 years from the closing date, and the structure and water penetration is guaranteed for a period of up to 7 years. And the intention is, if the builder goes bankrupt, then the new home buyer still has the right to go back to TARION, who will then look after these issues. Now, in terms of the things that impact a new home buyer, the main thing impacting a new home buyer is, quite frankly, the extension of closing dates. And typically what the Act requires is it requires the builder provide essentially a bunch of dates. The two key ones are the first possible closing date and the last possible closing date, which could be typically 18 months apart. And it requires that the builder, if the builder delays any of these dates, must provide the buyer 90 days notice in writing, so as they can make decisions regarding the sale of their house or giving notice to a landlord. Where the builder fails to provide that 90 days notice, then the home buyer is entitled to certain compensation. And the compensation regime has changed over the years, and I would encourage any buyer to really consult TARION, who has their own website and also call center to answer questions relating to that. The other thing is the unfinished home provisions of the Act. And as I mentioned earlier, once the municipality issues the occupancy permit, the new home contracts require the purchaser to move in. However, the unfinished items are not simply guaranteed by the builder. They also fall under the TARION guarantee, and those items are typically listed in what's called the pre-delivery inspection, and their inclusion at that form is a virtual guarantee that they will be completed, even if it comes to having to be done by TARION itself. So that is basically not a concern, even though a lot of people are effectively uncomfortable with it. The other aspect of buying a new home is essentially the variations allowed under the new home contract. The variations allowed under the new home contract are typically that the builder is allowed to, for small variations in size, the convention is up to 5%. The builder is allowed to build a mirror image home, and there is allowed to be certain changes to the exterior of the house as well as one of the most significant things is the changes in elevations. And elevations are whether you walk out of the first floor onto the backyard, whether it's a walkout from the basement, or whether there's somewhere in between with a deck. Because the architectural control and the elevations are controlled by city regulation, the builder always reserves the rights to change them at the request of the city, and will normally not agree to restrict those rights. Now, the last thing that I'd like to go on, where lawyers are really important in the process, is the additional costs. Typically, if you look at a new home contract, the builder is agreeing to deliver a home to a purchaser at a specific price, but with an add-on that the buyer will reimburse the builder for certain expenses. Those expenses, what we are seeing in 2014, are typically $4,000 to $6,000 per home. The most important thing in consulting a lawyer is that the lawyer explain to you what I've just before, but also that the lawyer be able to itemize for you what those additional costs are. So when you're going to close that house a couple of years down the road, these additional costs do not become a surprise. Our particular concern is identifying which items are clearly identified versus ones that are essentially a blank check for the builder. And what we typically try to do is negotiate a cap or limit on those items. The two most important ones, I think, that typically come up in a contract is the builder will reserve the right to back charge a buyer for any increases in the capital taxes paid to the city, such as education or development levies. And it's not uncommon to see that that is increased by $5,000 between when the house is sold and purchased, and the builder's asking for that amount of money. Typically what we want to do is get the builder to agree to a limit. $3,500, for example, is a typical limit we see nowadays. The other one, which is very rare but should be a concern to a buyer, is I mentioned about the changes in elevation. Result usually is that if a building has a walkout, the builders usually want to be compensated for the additional work if that wasn't originally anticipated, and they basically say that you'll compensate them without specifying the amount of money. And typically what builders are looking for a walkout is an additional $10,000 or $20,000. Well, as a lawyer, we want that spelled out. And the, I guess, last thing I want to address is HST and new homes. HST is applicable to the sale of all new homes, and they're often advertised as included in the price, which is slightly misleading because HST is only included at a reduced rate, assuming that the buyer is moving into it as their home or buying it for an immediate family member. If the person is not, then the purchase price is increased to make up for the discount that was given in HST. So the rule of thumb is, if the purchase price of the house is below $450,000, then that increase in price that the builder has to collect if a person does not qualify is 8%. Above $450,000, it's a flat $24,000. Okay, so 3 things about the rebate where it's applicable. So the bottom line is the builder has to ascertain whether the buyer qualifies for the rebate. If the buyer does not qualify for the rebate, then the builder is required to collect the additional 8% or whatever the amount is from the buyer on closing. Now, if the person is buying what's called a secondary residence or personal use property, in other words, they own a house in the city of Toronto, and the house they're buying is a cottage in Minden intended to be used as a cottage, then it is not entitled to the exemption and the additional amount must be paid. There is a program for rental housing which requires the buyer pay the additional HST to the builder. The exact same amount will be returned to the buyer later once they submit an application proving that they rented the property for a 1-year period to a tenant. The requirement also is that they maintain ownership of the property for a 1-year period. And the third category really has to do with the person who flips the house. They're not entitled to any rebate whatsoever. So I hope that you found this video informative. I do want to make a final comment about buying a new home, and that is the regulations that have been introduced make the purchase of a new home very safe, and they virtually eliminated all the big financial risks with buying a new home. However, my word of caution would be that when it comes to the small items, the new home warranty regulations and so forth are not very good in, do not necessarily address items that are, let's say, a couple $1,000 problem versus a $10,000 problem. And while I point this out, that's virtually the case in any real estate contract, whether we're talking new home or resale home, but it's something to bear in mind when you're dealing with a lawyer. Now, I'd like to make a final point, and that has to do with, I'd like to quote Susan Elliott, who is the past head of the Law Society of Upper Canada, in a video where she describes the lawyer's role in a real estate contract. And I think I'd like to remind everybody that when you go to buy a new home, of all the people you go to deal with, the real estate agent, the bank, the mortgage broker, an experienced real estate lawyer will be by far the most experienced person that you will deal with and will probably be the most helpful. While real estate agents and mortgage brokers close a few deals a month, most lawyers like me are closing 30 to 60 deals a month. And over the years in my office, I myself have closed over 20,000 transactions. And simply outside of the legal profession, you do not find that level of experience and assistance for you as the home buyer. I thank you very much, and I hope you found this informative, and I would encourage you to download our newsletter, which covers this same topic area. Thank you very much.